Well, good evening and welcome to Apex 320. As I said before, Apex 320 means the third Tuesday of the month for 20 minutes. However, this next segment that we're going to have, it goes beyond that. It goes to about 40 minutes because it's so important. I just felt that we needed the extra time, and I didn't want to stop my friend Gloria, who's an attorney, Gloria Pacheco. So we went right through the segment, and it took 40 minutes. So I hope you give me a little bit of grace that we went over the 20 minutes. If you can't watch the whole thing, then I ask that you pause it, do what you need to do, and then come back. We've talked about some very serious subjects and topics, and I know that you would be so interested. So again, give me some grace. We did take over the 20 minutes, but I know that you will be blessed. Thank you, and watch our Apex 320 tonight. Hey, welcome to Apex 320, taking it to the top. I am super excited to have my friend and attorney Gloria Pacheco. Welcome, Gloria.
Good evening, Kathy. Thank you very much for inviting me here today. It's my pleasure to be here with you and your guests.
Amen. Just can you give a little bit of a background? We have so much to cover tonight, so if you could just give us a little background of your position.
Sure. I am an attorney, and I'm licensed to practice in the Commonwealth of Massachusetts and the state of Rhode Island. I focus my practice primarily on estate planning, wills, trusts, and so forth, as well as real estate. So if you're buying or selling a property, real estate, commercial, residential, that's what I do. Those two areas are my focus practice areas.
And I also know that you have high honors. Wow, you're a very smart woman.
Many, many years ago.
Yes. Well, welcome. We have so much to cover. And what I'm going to do is I have 10 questions. And just so our audience will know the questions that we're going to be talking about, and then we'll go back.
Sure.
So, for instance, we're going to talk about what is a will, what is a living trust, is one better than the other, why do we need a will, when should someone consider doing a will, what happens to someone's belongings if they don't have a will? And if you do have a will, can you change it or cancel it at any time? You know, what can we put into place to know that our kids will always be taken care of? How about if someone may say, I don't have belongings, I don't have anything of value. Should they should they have a will? And once you do that will or that living trust, who do you give those copies to? Those
Sure.
good questions?
Absolutely.
Okay. So let's start off, Gloria, with what is a will and what is a living trust?
Okay. So a will and a trust are two separate documents, and they serve two separate functions. Me personally, I have a will and a trust, and I recommend most people, and we consider that area of the law estate planning. I'm sorry, I speak with my hands.
That's all right.
Estate planning usually consists of several documents, a will, a trust, be it a living trust or an irrevocable trust. There are many different kinds of trusts, perhaps a healthcare proxy, and as well as durable power of attorney. Some people even like to put in place arrangements for their disposition of their body, for burial, a funeral, etc. So that's those documents are covered under the umbrella of estate planning. So a will, what a will is you put in writing When you pass away, who do you want to take care of your assets, or your estate, as we call it? So we call it now in Massachusetts a personal representative. In the old days, it was called an executor. If you had a will, if you didn't have a will, it was called an administrator. So you can select, when you draft your will, while the attorney drafts it, you sign it, you tell the attorney who you want to be in charge of your assets. So if you have children, which child, or if you want your spouse, or maybe you don't have any children, and maybe you don't have any spouse, you're widowed or divorced, or you never got married. So who would you want to be in charge of your estate? Would it be your sister, your brother? Would it be your nephew? So you select your personal representative. And then, like you said, sometimes we don't all have lots of money, but whatever we do have, who's going to be in charge of it? Who's going to be in charge of cleaning out your apartment, giving the items to charity, and then the second part would be who gets what? So perhaps you don't have millions of dollars, but you have a vehicle. Who would you want the vehicle to go to? You have some jewelry or some sentimental items or family photos. Who do you want it to go to? So in your will, you can designate who's going to be in charge of your estate, who's going to get what, and then if you do have children, then who's going to get what when. So perhaps you have children, but again, you can do your will at any age. I was 32 when I had my first will, and I have no kids. But you can select who's going to be the guardian of your children if they're minors, okay? And then even if you pass away, God forbid, and they're not minors, you may not necessarily want them to get your assets or their inheritance when they're 18 or 21.
Yeah, right.
Perhaps you delay it and you say in your will, my kids will get it when they're 30, or half when they're 25, half when they're 30, or when they're 50. So you can put those in.
Wow.
So in your will, you can designate all that. If you don't have a will and you pass away, and let's say you're single, if you're married, your spouse will have will be in first position to petition the court to be the personal representative over your estate. So he'll have the primary role. But sometimes the spouses don't have capacity anymore. So now which one of your children is going to go to the court? And sometimes in good, happy families, now conflict arises, and now there's tension, and now you've created a scenario that was uncalled for. Had you just selected, this child to be the PR, and if she was unavailable or unwilling, or she dies before you, we never know, it would be this child. If you select it, there tends to be less dissension, less arguments. They just follow what mom wanted. Whereas if you have nothing in place, now you have 3 or 4 kids all vying. They all think they're the ones who are more responsible, or they think that's who mom would have picked. And now you've created discord, which is not the goal.
Right.
And it doesn't matter how much you have. If you have a little bit or a lot, dissensions sometimes happen. So if you don't have a will, then your family or your friends, they'll be responsible for petitioning the court to be appointed as personal representative, or sometimes the court appoints co-personal representatives. They have 2 or 3 who are all in charge.
Wow.
But now it's more paperwork. And then who gets what? If you have kids or a spouse, chances are it's going to go to them. However, if you do not have a will, the Commonwealth of Massachusetts and the state of Rhode Island, they have statutes that designate who gets what when. And they're complicated statutes, because if you have a primary residence and you're married, then it's one way. If you have primary residence, you're married, you have children only from that spouse, it's one designation. If you're married, you have children from that spouse and children from another relationship, there's a different set of rules.
Wow.
So,
wow.
Well, the Commonwealth has tried to do what someone would have done if they forgot to make a will, because sometimes we die prematurely. We always think after you retire, then that's when you're.
Right.
But sometimes we die younger, in our 30s and 40s and 50s.
And we've seen that with the virus right now, right?
Unfortunately, yes.
Yes.
So both Massachusetts and Rhode Island have statutes to account for that, but perhaps you want to account for it differently. For example, maybe your daughter won the lottery, she's in California and she's doing just fine, and you want to give it all to your 2 sons who are living locally. So you can do that. So in your will, you can also you can do different amounts of different kids. When you don't have a will, they pretty much do it all equally. The other thing is, if you want to disinherit a child. Unfortunately, there are cases where, again, the daughter won the lottery, they're in California, they haven't spoken to them in 20 years,
Right.
and they're just going to leave it to the two boys who are here locally. So with a will, you designate who gets what and who's in charge. If you don't have a will, then the Commonwealth is going to designate who gets what and who's in charge. And we also have to give notice to all those people, which is, the probate process. The
Right.
probate
Goes to
court
probate.
process takes several months, if not years,
Yes,
depending on the
right.
complexity. Yes.
I have heard that. So it's so important that we do have either that will or that living trust, because
Yes.
that's exactly what happens.
Yes.
It does go to probate,
Yep.
and it can take years.
Yeah.
You know,
There are some complicated situations,
right,
yes.
And it can cost you lots of money.
Lots more
of
money. But even more important is the dissension in the family.
That's true.
Because it's so much up in the air, and everyone's trying to vie, to be responsible, what mom would want them to do, or dad
Right,
would.
right.
And in reality, that mom would not have wanted them to have any discord.
Right, that's so true. And I thank God for my mom, because my mom did have a will, so that worked out so well.
Perfectly.
So it
Okay.
worked out really nice, because there's four girls, so that's tough. So do you think that one is better than the other, or should you have both? Like I think
You should have
said-
both. You should have both, but if you, the trust is better, because with
Right.
the trust is more expensive. However, when you have a will, the original will needs to go to probate court, needs to be admitted, and all that stuff. And you have to go through the probate process with your will. If you don't have the will, you still go through the probate process, but then who gets what depends on the statutes of the state you're in or the Commonwealth. With a trust, you avoid the probate process altogether.
Right.
And by avoiding the probate process, that saves you time and money, and it's also private. So whenever you probate your will, you then have to give, let's say I probate my will and my brother is my personal representative, my PR. He's going to give the court an accounting of all my assets, all my debts, who gets what, is going to do all that good stuff. With my trust, my brother takes over. Once I have my death certificate, he takes over as successor trustee, and he can distribute whatever I have, sell my condo without a license to sell from court. The trust will give him that ability, so he can sell my condo within weeks or months without court approval.
Right.
And he divides it to whoever the beneficiaries are of the trust, and it's not public record.
So let me see if I got this. So if you have a will,
Yes.
either way you have to go to court?
Yes,
So if
probate.
you have a will, you still have to go to court.
Yes.
Where a living trust, you don't.
Any trust, you don't.
Any kind of trust, you...
You don't have to go to probate court, and that makes it more efficient, ends
Right.
up being less expensive, and the whole
Right.
process is private.
Or a trust is actually better.
Yes.
Correct?
However,
Okay.
let me give you an example. I have both a trust and a will.
Okay.
So let's say I go to Foxwoods and I win $10 million, and on the way back have a car accident and die. Those $10 million, and I never gamble, I should. No. This is a Christian show, right? I never even buy a lottery ticket. But let's say that $10 million is not in my trust yet. So that means it has to go through my probate. And if my will is not going to say, take that 10 million, put it in the trust. Again, no one knows who's getting that 10 million.
Right,
So
right.
that's why it's good to have both.
I see.
Okay?
I
Because
see.
again, and sometimes people have car accidents, and let's say a drunk driver hit them. There's a lawsuit that ensues
Yeah.
because of that. So that money goes to the estate of that person. And then that money will be distributed pursuant to the terms of the will or the statutes if there's no will. However, if there's a trust, like the way I have it set up, the money goes to probate, and the will says give it all to the trust. It goes to the trust, so no one knows who's getting my 25 cents or my
Right.
$10 million.
Wow. So much to...
There is
much.
a lot.
Woo! I remember when I got into your office, I left there with a headache, So my next question is, when should someone consider doing a will or a living trust? When should they...
Okay, well, again, this is my specialty, and I really love what I do. Once you have children, I think it's paramount that you do your first will, because in a will is where you also nominate the guardian for your children or your child. And again, God forbid something happens, God forbid, but and again, hopefully nothing ever happens, but God forbid something happens, you want to designate who do you want to be the guardian of your child.
Right.
So, because again, we've seen instances where mom and dad die simultaneously in a car crash, but the little kid survives, the 1-year-old survives.
Yes.
So if you have a will, so when you have a child, I highly recommend is when you get your estate planning a little bit in order. So you can designate who's going to be the guardian. Will it be your mom? Will it be your sister? Will it be your cousin? Will it be your brother? And you don't have to agree with your spouse on this, okay? So, because chances are it's not going to happen. So the husband or the dad can pick whoever he wants. The mom can pick whoever she wants, okay?
Oh, okay.
Because chances are they're not going to die simultaneously, but if they do, whichever one dies last their will be the one that governs. There's no need to argue over the dinner table over who's going to be the guardian of your children. And furthermore, I don't recommend you tell that person you've selected them, because you may change your mind. So perhaps when the kid is 2, you think your sister has another 2-year-old to be the perfect family environment for your child, but perhaps when the child is 15, you want to change it to your sister-in-law because where she lives in her school system or whatever may have happened. And you, as you mentioned earlier, yes, you can change your will as many times as you want.
Right.
Okay?
Right.
And what I notice in general is people tell me how they want their estate, their will, the power of attorney, all this good stuff. And then within a couple of years, they come back and tweak it.
Yes.
Because they think a little bit more about it. And that's good.
Right.
And that's good. So to answer your question, I think once you have a child, you should do your will because then you can nominate a guardian for that child. And again, I always say, give me a couple, 2 or 3 people. So let's say you're a single mom. I'd say, Kathy, God forbid something happens to you, who would you want her to go to? You'd say, oh, my sister Mary. Okay, God forbid Mary is unavailable or she is deceased.
Right.
Who would it be? Say, oh, my sister, Elizabeth, whatever. And I'd like to put that down. And then God forbid something happens, which is very, very rare, but in the event that does occur, your sisters already know who was primary. If you don't have a will, and God forbid something happens to you as a single mom, and you leave a minor child,
right,
all of your sisters are going to go to court because all going to want to do the right thing by you.
Right.
They're all going to get an attorney. And now you have 3 attorneys, you have 3 clients, plus some of their spouses or significant others, and the poor little kid is caught in the middle.
Right.
Who's that helping?
Right.
So
right.
it's important to have your will done, and hopefully nothing ever happens to you, and you revise it 20 years later. But in the event something does happen, it's so much easier if you have a designated guardian for that child,
Right.
versus having each one of your sisters make a claim with their attorney before the judge that they're the better guardian.
Right, right. I know with myself, I think I'm up to I think I've done my will 3 times.
So have I.
Yeah.
And I've amended my trust a few times too, yes.
And I'm going to be going back again and working this out. Because when we did do our will, which was years ago, just like you said, our kids were young.
Yes.
We had certain people that we wanted them to take care of
Yes.
our children. Then things happened and we went back and changed it. Then as our children got older, now they're in their 30s, so now we had to tweak it again.
Yes, yes.
And say, okay, now they're responsible, now they can, so now again we had to change it.
Right.
And now we're in our 30 years old, and now we find ourselves having to change it again. What do we do with our house? I can't remember the word, when you put your house in
irrevocable trust.
Yes, I know that's another thing. So that's what, now being as old as we are.
You're still too young for maybe you're still too young for the irrevocable trust.
Thank you. But either way,
You're
that's
considering
another
it.
thing. We're
Yep.
considering
Yes.
that.
Yes.
And that's also important, and people really need to know that too, because if you end up in the nursing home, then that nursing home can come and take your home. So that's really, if anybody's out there over 60 or whatever, 70 and doesn't have a will, well, guess what? If you have a home or a car and you don't have a will, guess what? You go into the nursing home, your children don't get that. The nursing home gets that. Is that correct?
That is
Yes.
correct. I'm just going to clarify it
Yes,
because
go
I'm an
ahead.
attorney. I'm very nitpicky.
Yes.
In the event you do need to go to a nursing facility, a long-term care facility, in the event that happens, not all of us, some of us die peacefully in our sleep.
Yes.
But some of us may need to have that care. Let's say me. let's say I have a car accident leaving this place and I'm paralyzed.
Yes.
I need to go to a facility. Doesn't matter how old I am, right? I'm under 60, under 50. What happens is, once I go to a nursing facility, they're going to send me a bill. And whatever money I have in the bank, I need to pay them. Once my little savings runs out, then they're going to put a lien on my condominium, okay, and my vehicle and all that good stuff. So what the nursing home does is they put a lien on your assets. And because a nursing home costs $12,000 to $15,000 a month, if you have a home, that will easily be gone in a year or a year and a half. And as we all know, I'm sure we all know people who've been in a nursing home, and they're usually there for a little while. And then, as you said, it's very common that all their savings that they saved up, their major asset is their primary residence, that the nursing home ends up getting it. But they don't take the home. The process is they put a lien on the home, and then when the house is sold, they get paid. That's the process. So in the event I go to a nursing home because I have a car accident and I'm paralyzed, and I'm only there 3 months, they can only put a lien on my condominium for the 3 months I was there.
I see.
So let's say it's $45,000, and if my condominium was paid off and it's worth $200,000, then the rest would go to
that nursing home.
But only 45 would go to the rest would go to whoever I designate in my trust.
Right.
So just to let, again, chances are I would be in a nursing home for a year or 2 or 5 or 10 years. But in the event we were there short term, only a month or 2, they put a lien for the days we are there. Okay, that's how it works. So it's not that once you step foot in a nursing home, the house is gone.
Right.
It depends on the amount of time you're there.
Right.
But again, a nursing home is very expensive. We're talking $12,000, $13,000, $14,000, $15,000 a month for a semi-private room, which means you're still sharing the room. And then if you're there 2 or 3 years, even though your house is worth $400,000 and it's paid off, it goes to the nursing home pretty much, but it goes to the nursing home for the process of the lien. So if, like some people, after 2 or 3 months, they pass away, in which case when they sell the home, they pay the lien off to the nursing home, but the rest goes to the kids.
Well, and then
so that you know.
Right. Well, and then you do have people who are in the nursing home for 10 years.
Exactly.
And however you look at that, like you said, it's so much money.
Yes.
And your children could end up losing nothing.
Yeah.
I mean, that is so important.
Yeah.
I think that's why this is such an important segment, because down the road, your kids, you work so hard, you want to leave something for your children, however it is, and then you end up, like you said, whether it's a car accident or a nursing home, and they get left with nothing, and you've worked all your life. I know that is what my mother was so afraid of. She worked so hard, and she always wanted to leave something for her children. So thank God my mom did what she did, and she had that in order. She happened to have a living trust. And I think what's important too, because this happened to it's the wording. You have to be very careful with the wording that attorney puts on that living trust. Because you have a little word, which is what happened to my mom, just one little word, and she had to get that all revised because that little word, that nursing home could have, came in and took the house. So she had to have that whole thing revised again to make sure that, God forbid, if she did go into the nursing home, that they would not come, for the home.
And that's why I refer to it as a trust, because there are so many different kinds of trusts. Exactly like you said, a little word makes a big distinction. So I like to refer to it generically as a trust. Then when the client comes in and tells me what their goals are, what they want to achieve by coming in to see me, then I'll structure the trust accordingly.
Right.
Yeah, like your mom experienced that.
Yeah, that was so. Thank God she caught that, and I thank God for that. So I know you've talked about quite a the stuff that we've, but like we talked about, if there's someone that doesn't feel like, well, all I have is a car, I don't even have a house, or I only have $10,000 or $5,000 in the bank book, should they still do a will?
Yes, I do recommend them doing a will. I also recommend that they do a healthcare proxy and a durable power of
yes,
attorney.
Yes.
Okay.
Please explain that because that's very important.
Yeah, so let's say I have no assets whatsoever. I'm single, I have no kids, I pretty much pay my rent every week, and I probably have $3 or $4 grand in the bank and my car. And I say, I'm not gonna bother spending money with a lawyer because I have very little. I don't care who gets it when I die. Well, God forbid I'm in a car accident and I'm rushed to the hospital. What happens is someone needs to make healthcare decisions for me if I'm in a coma or if I don't have capacity. Someone needs to make that call. Is it going to be this surgery or that surgery? Are we going to try this medical procedure or this medical protocol? So you need to, they need to call the next of kin. So in my case, I have no kids. I have 9 brothers and sisters. Good luck picking one of them.
Yeah.
So who has authority to tell the doctors what's going to be what? They have to go to court to petition for a guardianship over me and a conservatorship over my assets, and that's time. Time is money, and then you create discord and dissension.
Right.
Whereas if you have a healthcare proxy in place, God forbid I'm in a car accident, I show up at the hospital, and they know, oh, she wants to contact her sister to make the decisions. They call her. She's not available, the other sister. Or she doesn't want her sister, she wants her neighbor or her boyfriend or whomever she has. It's written down. And then the quicker the doctor and they get information about your care and what to do, the better, hopefully, the chances of me getting better and rehabilitating.
Right, right.
So even if you have no assets, I highly recommend a healthcare proxy, because if anything happens to you and you don't have capacity or you're in a coma, who's going to make decisions for you? Or let's say I get Alzheimer's. I'm 85 and I begin to get Alzheimer's. Who has authority to put me in a nursing home?
Right, right.
I have 9 brothers and sisters. They have to go to court and fight, or not even fight for, but they're all going to try to do the right thing and do the right thing for me. But in reality, I want my sister so-and-so to take care of all that.
Better be a sister that you get along with.
I thank God I get along with all of them.
Yeah, or else they're going to pull the plug, even if you don't want to pull the plug.
But to that point, some people tell me, if I'm in a vegetative state where I can no longer communicate, I don't want to be on a ventilator forever. And we can incorporate their wishes into the healthcare proxy.
Right.
Again, I don't like to get too specific because medical technology changes so much in a 10 or 20 year span. But even if you have no assets or very little assets, and you live in an apartment, you want to know, you want to designate who's going to make the healthcare decisions for you. And again, once you pass away, who's in charge of cleaning your apartment, getting rid of your assets? If I pass away and I live in an apartment, someone does not have the right to just come in and do what they want with it, with my assets or my little knickknacks or my photographs. So you have to go to probate court. And so again, it's not mandatory you have anything in place, but I highly recommend you do. So God forbid anything happens to you, whoever you designate will be the one making the healthcare decisions for you. Whoever you designate will be the one cleaning out your apartment and taking the photographs, taking your jewelry without any issues in court of someone stealing your assets after you die.
And that's important because I'm not sure how many more minutes we have, but however, I know with my mom, as you know, my mom and dad both passed away within 6 weeks, and we wanted to sell my dad's car, but my dad's car that was I think maybe the one mistake they made, and it was only under my dad's name.
Yes.
So we had a hard time trying to sell that car, and it was going to be to my sister.
Yeah.
And even with that, we had a hard time trying to sell it because it was only under my dad's name. It wasn't even under my mom's name or whatever. So that was I think one. Go ahead.
Because again, it's in your father's name, so that's his estate. So technically, that car needed to go through the probate process.
Yes.
Because otherwise, who has authority to sign that title?
That's right. That's right. And it's something we take for granted. So, what's a car? Well, guess what? That car could be sitting there and whatever. It's just that, to me, I think it's so important. I don't care how old you are.
Right.
When my husband and I, we did it, we were like in our 20s. So you may be out there saying, well, I'm only in my 20s. I don't care. I think it's something that you really should have,
Yeah, well, exactly to your point. So maybe you're 29 and you're married. You got married a year ago. Who do you want your assets to go to? Your parents, your siblings, your wife, maybe half to your spouse, wife or husband, half to your spouse, half to your mom, maybe a third to your spouse, a third to your mom, a third to your dad. Even if you don't have much, do you want it all to go to your spouse? Or you're not married?
Right.
Do you want it all to go to your mom and dad, or your sibling, or your little brother?
Right.
Or a charity, like the Red Cross or Seven Hills. Yeah.
Well, I have another. This is a tough question. And for instance, maybe you can help me with this. So here you are, you're married.
Yes.
And your spouse passes away and they get remarried. Correct? Now, if I'm not mistaken, that spouse gets everything and your children do not get anything.
It depends.
Okay, because
depends.
I just heard that. I know that's a tough thing, because here I am. I want to leave my stuff for my kids, right? My husband, God forbid, remarries, which you better not, remarries. This woman has kids. It could be possible that that person, that wife or whatever, their kids gets my daughter's stuff.
I'll tell you the scenario.
That's tough.
It is very difficult, and I'll tell you the scenario where that would happen. So husband and wife are married. They own a home, and that's their primary investment. That's their primary, wealth is in that home. So say the wife dies unexpectedly. Usually the way the title is held, the deed to that house, is for the husband and wife, and when one dies, it goes to the other. Tenants by the entirety is the most common. So God forbid you were to die, let's say you were 50 or 40, the house would go automatically to your husband.
Correct.
And then he remarries 10 years later to a nice lady. Well, now she has marital rights in that home, even though the deed is only in his name. So then when your husband dies,
she gets it.
She has, if he never puts it in her name, she has the right to live there for the rest of her life, even if she remarries, and only then would it go to to his kids and half to her upon his death. But what typically happens is this: God forbid you were to die at age 40, and your husband remarried. Chances are they're going to buy a new home. They're going to sell your home, use all of that equity, because she wants another house, not the house he shared with you. You buy a new home in both of their names, and then you're exactly right. Your husband passes away, because typically the men die before the women, and then that house is in her name only, and she leaves it all to her kids and nothing to your kids.
Yeah.
So in a case that, that could happen.
I know. When I found that out, I said, I'm going to go see my friend Gloria right away.
Right. So in that case, you want to have a trust, so that in the event one spouse dies before the other, you want to say, my half goes to my kids. Your half you can do whatever you want with.
Right.
Yeah, that's a good question.
I know. When I found that out, I said, we better hurry up and make that appointment with Gloria. But anyway, we just have a few more minutes. Gloria, thank you so much. I know when I went to your office, we were there over an hour. I left there, my head was spinning with so much information that you gave us. And I'm sure maybe some of yours are spinning too right now. But if you would like to contact Gloria, her office is at 411 Columbia Street. You can reach her at 1-508-6733-646.
Yes.
Right? And we have a special offer that if you do mention Apex 320, if you go to her office, you say, hey, I listened to that program 320, Apex, she will give you 20% off on your first consultation. Isn't
Absolutely,
that right?
yes.
Isn't that great? So I hope you enjoyed this. I know there was so much information. Maybe you might have to hear the program over and over and over again. But feel free to contact Gloria. She's very informative. She'll help you. I know she's helped me. And I thank you for joining in. I hope this was a blessing. I hope you got ministered, and I hope you do get that will done, that living trust. Thank you for joining us. And I just want to say a quick prayer. Father, we thank you. And Lord, you've asked us to get our house in order. And Lord, this is one way that we need to get our house in order. And we pray that we would take all this information and allow us to get our house in order in regards to a will and a trust. Father, we thank you. We thank you for Gloria. We thank you for her being here. And we just pray that you just have a blessed day or night. Thank you for joining us, and see you next time, taking it to the top.